as I hear him called, is again a fantastic addition to our panel today. He's got numerous qualifications, including a law degree from Queen's University Belfast, as well as a PhD, and a PhD in jurisprudence, no less. Hart and Austin's philosophies. Very pleased to see it's still a robust area of discussion, much maligned is jurisprudence, but it's a great foundation for what we're doing here. But look, I don't want to take up any more time. Thank you so much for coming here to New Zealand to inform us. So the floor is yours.
Well, good afternoon, everybody, and thank you so much for allowing me to come along here today and to address you on these important issues. I want to thank Mike especially because he first contacted me about the work that we were doing and extended the invitation to us to come and speak with you. I'm of the opinion that this sort of international collaboration is extremely important. I was just minded by the comments of David earlier this afternoon, when he said that occasionally, as a victim of a miscarriage of justice, you might get into a rather dark place when you think that nothing is happening. I can assure you, David, that as researchers on miscarriages of justice, we have visited those dark places very often because we sometimes have an appreciation that somebody has been wrongly convicted. We are doing the very best we can to do something about it, and then the institutional forces that have occasioned this wrongful conviction seem absolutely determined not to respond or to do anything about it. And that makes us feel very frustrated, and it creates great difficulties for us sometimes when we think to ourselves, what's the point? How are we ever going to move on from here? And so, in relation to a number of our cases, we had put in petitions. As Bibi mentioned, we had to wait 4 years just to get a no from an Attorney General on Mr. Keogh's petition. We think that in some circumstances, the situation that we've been through over this last number of years is really quite disgraceful. I would like to be able to explain to you something about the cases that we have worked on, because I think it's important that we share our experiences with these cases. I also think it's important that we provide that sort of peer review that Bruce MacFarlane was referring to earlier. Remember when he was saying that working on difficult cases, you need to bring in somebody who'll provide you with a pair of fresh eyes to review the case. I think that as we work on miscarriage of justice cases, we too need to bring in fresh eyes sometimes to look at the cases that we're reviewing. I can remember many years ago, we approached AIDWIC, now known as Innocence Canada, to help us with an independent review of the Keogh case. I think sometimes it might help if you have cases in New Zealand, if you can reach out to people in either the UK or maybe in Australia and say, would you have a look at this case for us? And let us know your honest opinion as to whether it constitutes a miscarriage of justice and whether you might be able to provide a report to us about why you think it perhaps is a serious miscarriage of justice. So in South Australia, we had often sought an independent pair of eyes from people from interstate and sometimes from overseas to help us build the case that we want to argue and to try to bring pressure to bear upon those officials in South Australia who seem very determined not to do anything about these cases. So with your permission, I'd like to go through some of the issues that we've tackled, explain to you what the problems are, and then seek your opinion as to whether you think that this is merely an act of cognitive dissonance on the part of these state officials, or whether in fact it might be something a little bit more serious than that, and a clear determination, I think in some cases, not to correctly apply the rule of law. One of the reasons, and if I may just digress just for a second, one of the main reasons that I'm so concerned about this is that I did my law degree in Belfast, and I did it there during the Troubles, as they euphemistically called it. During the time that I was there, around 3,000 people were killed in shootings and bombings. It was not uncommon for somebody to knock on the door of somebody's house, and when they answered the door, they'd be shot dead. It was not uncommon for bombs to be placed underneath cars that would be set to go off at a certain time. And if some person just happened to be wandering past, as happened on one occasion when the grandfather and grandchild were just walking past and the bomb blew up and people were killed. I was involved in the very first daylight bombing in Belfast, and I can report to you that if I'd come back from lunch 90 seconds later, I would have been the first person to have been killed in a daylight bombing in Belfast. I had come back from a lunch. The bomb was placed underneath the stairs on the ground floor. I had just walked up those stairs to the first floor. I went through a set of double doors to my office and then walked about 10 paces beyond the double doors that saved my life when the bomb went off. So 90 seconds and I'd have been a goner. I have to say that that helps to focus your attention on the importance of the rule of law, and I have a very firm commitment that the rule of law is important and it applies to each and every one of us, including prosecutors, expert witnesses, and of course, judges. I fear that sometimes in the work that we have done, we have exposed not just unintentional error, but a deliberate intention on the part of some of those officials not to apply the law correctly, and perhaps because of fear of embarrassment or the consequences that it may lead to. But whatever the reason, it is totally unacceptable. And that's why I think it's important for us to step outside of South Australia and then to explain to you what's gone wrong over there, in the hope that some of you might think, well, we're all part of this international community. We all depend upon roughly the same laws applying, and we still depend upon justice and fairness applying in each of our societies. And if it is that wrong over there, and maybe we can make a contribution to that, they in turn can make a contribution to the things that are going on here. So I think that that's the dynamic that we need to build more of, and I'm very grateful, as I say, to the Justice for All People, giving us the opportunity to participate and share in this process. In starting my analysis, I would just like to be able to... there we go. If I could just demonstrate this. I would just like to reassure you that everything I'm telling you about today has been published. There's nothing secret here. And in fact, much of it has been published a very long time ago. As you can see from our website, it's been our policy throughout the whole of our research over a period of about 20 years to ensure that all that we do is done in public. All of the submissions that we make, all of the petitions that we have lodged have all been placed on our website as they occur. So you can actually see what's been happening. And it's also important because I don't want any of these public officials coming back later and saying, oh, well, thanks for bringing that to our attention, Bob. We didn't realise that this had gone wrong some years ago. I wish to deny plausible deniability to the officials who behave badly, and I would encourage you to think of doing the same. As a way of illustrating that, we started working on miscarriages of justice in the year 2000, and if I can find out how this works. So if you click on the radio and television programmes link on my home page, and then go to the very bottom of that page, you can see at the bottom there, 22nd of October 2001, ABC Four Corners expert witness. By October 2001, we had been working on our research on miscarriages of justice for about 12 months. It wasn't difficult for us to find the things that I'm going to report to you today. They have been on the public record, as you can see, for 18, 19 years, and virtually nothing has been done about them. So please bear that in mind as we discuss these cases. You can see, as we get to the top, that we have done 135 television and radio programmes. When we did the ABC Four Corners programme, we rather naively believed that if we reported clear and manifest miscarriages of justice, then the officials, the Attorney General, the Solicitor General, the Parliament, the government, whoever it was, would actually do something about it. I remember saying to Bibi, miscarriages of justice wasn't my major topic of research at the time. I was doing some other things. I was going to take a bit of time out to work on miscarriages of justice. I thought it might take us maybe 12 to 18 months to provide a proper report on what had gone wrong, and then we could get back to our main game. I had no idea that 20 years later I'd be standing up in public and talking about these things. In 2001, we published the programme, and in 2004, we published this book, A State of Injustice. After the programme, the Attorney General had said that we'd been mischievous, that we were misreporting things, we'd misled the reporters on the ABC, and that really there was nothing to be concerned about. So we thought, again naively, if we wrote it down, provided footnotes and quotations from the relevant transcripts, that would speak for itself, and then they would do something about it. That proved not to be the case. Because the case of Henry Keogh was going to be our lead case, we thought, well, maybe if we just wrote a book on that, that would make it a little bit more clearer. And so we published that in 2006. We can tell you now, with the benefit of hindsight, that in Chapter 11 we set out the grounds on which we thought Mr. Keogh's conviction was a wrongful conviction, and essentially that provided the basis on which his conviction was subsequently overturned 8 years later. Because it was being suggested that we were being mischievous and that we weren't really credible authorities on these things, we thought we better try and correct the balance and the perceptions. And so that's when we worked with Kent Roach, Canada's leading law professor on the topic of miscarriages of justice. And in 2010, we published this book, as Bibi mentioned. And then afterwards, we published this one on the new right of appeal. Essentially, the case law that we've worked on has remained unchanged since October 2001. So let me mention to you briefly, run you through the sort of cases that we've been dealing with. Mr. Fritz van Beelen was convicted of the murder of Deborah Leach in 1971. The evidence put against him at the time comprised essentially important evidence by a forensic pathologist. His name is Dr. Colin Manock. He was the chief forensic pathologist in South Australia, and he'd been appointed to that position in 1968. So Van Beelen was to be his first major case. The important thing about the Van Beelen case was that the time of death became absolutely crucial. It was known that Mr. Van Beelen had left the beach by 4:30, and it was known that Deborah headed down to the beach at 4 o'clock. It was therefore important from the Crown's point of view to establish that the death had occurred between 4 o'clock and 4:30. Dr. Manock was not only the chief forensic pathologist, but he was also a very obliging sort of fellow. And he was able to give evidence at Mr. Van Beelen's at his trial, in which he said, "I am satisfied that Deborah Leach was dead by 4:30 and no later, and of that I could be virtually certain." You have to remember, of course, the effect of the independent expert witness in the box giving clear and unequivocal evidence about which he has no doubt, and regrettably often about which there's very little challenge. She was dead by 4:30 and no later, and about that I could be virtually certain. The way he established the time of death was to have a look at her stomach contents. The removal of a sample of stomach contents at autopsy is a very standard procedure. It may be used for the purposes of toxicology to see if the person had ingested any drugs or stupefying agents or anything of that sort. It became clear to Dr. Manock about 3 months after the death that the time of death was going to be important. He went to the freezer, which contained a small jar of stomach contents. He removed that from the freezer. He thawed it out, looked at it, and said, "That looks like between 4 and 4.5 hours to me." We have to say that that has absolutely no scientific basis to it at all. And in fact, Professor Derek Pounder, who then was just a humble Dr. Derek Pounder, was so surprised at this that he actually wrote some scientific articles and said that on the visual inspection of stomach contents, the most that you could do was to give a time of death plus or minus about 3 hours. He said to try and time it down to a half-an-hour interval would be impossible. Just a few years ago, we managed to get Mr. Van Beelen's appeal back to the High Court in Australia, and expert evidence was given to that effect that it is still impossible to time a death to within half an hour on the basis of stomach contents, and the High Court accepted that that in fact was the correct position. Regrettably, there was also some hair and fibre evidence which it was said showed that there had been contact between Mr. Van Beelen and the young girl, and regrettably that evidence was not challenged by the defence on this recent appeal, and the High Court said, well, if that's the way the evidence stands and there had been contact between these two, then the actual time of it doesn't really matter. And so his conviction was upheld. And of course, as Bruce MacFarlane will tell you in his recent articles, which we've put on the Canada page of our website, to use hair and fibre evidence as indicative of contact between individuals has been thoroughly discredited for at least 20 years. It clearly should have been challenged, and it wasn't, which is most unfortunate. It means that the Van Beelen appeal can go back through the appellate process again. In a couple of other cases involving the same forensic pathologist, the evidence that he gave was a little strange, let me put it that way. In the case of Gerald Warren, he was a 15-year-old boy who was found dead on a dirt track just outside Port Augusta. This is a small town about 3 hours' drive north of Adelaide. Dr. Manock had gone to the scene and he had examined the body, and in his report he said, "I believe that Gerald Warren had been intoxicated and that he had fallen from a moving vehicle. He noticed that Gerald had an injury to the back of one of his hands and the side of his face. And he also noticed that there were some slight parallel marks within the injuries that he had received. And so in his autopsy report, he said this young lad is intoxicated. He fell from a moving vehicle. And in doing so, the back of his hand and the side of his face must have come into the contact with the corduroy of his trousers. And therefore, essentially, it's an accidental death." A few weeks later, a woman goes into the police station in Port Augusta and says, "I'm very concerned about my brother-in-law who gets drunk every now and again and goes on about what they did to the Abo kid. The police think we should check up on this, so they go out and see them." He actually explains what, in fact, they did to the Abo kid. They were driving into Port Augusta, and as they drove past this group of young lads, one of them, Gerald Warren, had just finished his bottle of beer, and he thought it would be a little bit amusing to throw it into the tray on the back of a utility vehicle that these two characters were driving, and it bounced around in the back of the ute. They took exception to this and thought that that was not a very polite thing to do. They went to the bottle shop, they got a 6-pack of beers. On the way back up the road, they waved them out of the window and said to Gerald, "Why don't you come and join us for a drink?" And he said, Oh, terrific idea. Hopped in with them, off they went, out to where this dirt track was. They get out of the vehicle, they're standing round by the back of the vehicle, and one of them reaches into the tray at the back and takes out a scaffolding bar and begins to bash him about the head and body with the scaffolding bar and beats him until he goes unconscious onto the ground. He then says to his mate, "Get out the way," he says, "I'll run him over." And he does so. He reverses the vehicle back over Joel's body, back wheels and front wheels, comes forward again with the front wheels. His body snags on the exhaust, and the fellow stabs on the accelerator, spins the vehicle round, and the body is thrown out into the bush. And off they go. The trouble is, you see, that these two fellows were charged with murder, and at the murder trial, the evidence goes a little bit like this. Well, Dr. Mannock, I understand you say that the injuries to his hands and face have been caused by the threaded end of a metal pipe. Yes, that's correct. But I also understand that in your earlier report, you said that they had been caused by the fabric of corduroy. Yes, that's correct. Isn't that a bit of a problem? No, it's not a problem. Well, could you explain it for us, please? Yes, of course. If you were to impress the fabric of corduroy against the skin on the one hand, or you to strike it with the threaded end of a metal pipe, the physical forces involved are very similar, and the injuries would be indistinguishable at autopsy. Now, I don't know if there's anyone here who's inclined to go along with this, but we could kind of run a little experiment, couldn't we, and get my little corduroy cushion out and my metal bar out and offer you a choice. And I would assure you, on the basis of Dr. Mannock's evidence, that it doesn't matter which Q you form, it's going to feel the same. But then it carried on much in that vein. Well, Dr. Mannock, I understand you say that this young man was killed by having the vehicle driven backwards and forwards over the top of his body, yes? But earlier I understood you to say that he'd actually fallen out of a moving vehicle. Yes, that's correct. Isn't that a problem? No, it's not a problem, he said. And you understand now how this is going to go, don't you? If you are thrown out of a moving vehicle on the one hand, or have the vehicle driven backwards and forwards over you on the other hand, the physical forces involved are very similar, and the injuries would be indistinguishable at autopsy. It's plainly nonsense, isn't it? But please bear in mind that at a criminal trial you have 2 QCs, 2 junior barristers, 2 solicitors, and a judge all listening to this. And as we read through the transcript of the trial, I did expect somewhere for it to say, and the judge threw his wig on the ground and said, "Bugger me, that can't be right. What's going on here?" But nobody did. Nobody said anything about it at all. In a later case that we had David Zack, who was a young man who was convicted of the murder of his older boyfriend. David was 18 at the time. His boyfriend was a 44-year-old criminal lawyer in Adelaide, whose body was found in a freezer at his home office. Dr. Mannock went to the scene, and whilst there he removed the body from the freezer and found it was frozen solid. He thereafter managed to insert a needle probe into the body and into the liver, so he got the core body temperature, so he knew how frozen the body was. From that alone, he was able to determine, for the benefit of the court, that this man had been shot and killed between 6 and 6:30 the previous Tuesday afternoon. He was asked if he knew the ambient temperature because, of course, when a person's shot and the heart's not beating anymore, it's not generating heat. And if there's a temperature differential, they will begin to sort of even out. So it's important to know the ambient temperature in the room when the person's killed. It's also important to know the time interval between when the person was killed, when the body was placed in the freezer. Knowing the temperature of the freezer when the body was placed in there would be helpful, but he didn't know any of those things. He merely said that he thought he was killed between 6 and 6:30 on Tuesday afternoon. And just as it happened, an eyewitness was there to say, "I think I saw David Zack or somebody looking very much like him going into the premises at 6 o'clock and came out at 7 o'clock. The prosecutor was able to tell the jury that this man was killed between 6 and 6:30 and the accused was there. Very compelling evidence, isn't it? In the other case that we looked at, we had a fellow called Terry Akrotidis, who was said to have committed suicide by jumping from a high tower and falling to his death. Dr. Manock didn't do the initial autopsy, but he was giving evidence to the coroner about what the autopsy report meant. And it goes a bit like this. Well, Dr. Manock, I understand you to say that this young man has committed suicide by jumping from a high tower. Yes, that's correct. Are his injuries consistent with having jumped from a high tower? Oh, well, says Dr. Manock, I suppose it depends how far he'd fallen, doesn't it, really? Would it have been 150 feet, 250 feet, 350 feet, 450 feet? And then in the transcript it goes ... indicating that he was interrupted, and thankfully, by the coroner, who said, but Dr. Manock, I understand the tower's only 150 feet tall. Could we assume that he hasn't fallen any further than that? So Dr. Manock said, oh, well, look, I mean, if he's fallen 150 feet, his body then struck the roof of the adjacent building, landed on the ground, and according to my calculations, he says, oh, let me see now. Oh, yes, he would have hit the roof at 100 kilometres an hour. What makes you think that his body hit the roof of the adjacent building? Well, because it had a hole in it where he hit the roof. That's why. I see. Is there anything that we need to know particularly about the roof of this adjacent building that had the hole in it? Well, he says, it was made out of concrete. It was 2.5 inches thick, and it had 3/4-inch metal bars running through it in a 3-inch mesh. So it's a thick concrete roof, heavily reinforced, and apparently the impact of his body knocked a hole in it 1 foot square. Well, now, Dr. Manock, can you tell me, did this young man have any serious external injuries? No, he didn't. No. Are you surprised by that? No, I'm not surprised by that. Could you explain it? Oh, yeah, it's quite simple, you see. And this, you have to listen to this very carefully. He didn't have any serious external injuries because his clothing was interposed between his body and the surface that it struck. Now, what that means in plain, ordinary English is this. He had a shirt and a pair of jeans on. He was actually falling partially inverted, according to Dr. Manock, so that would be head first. But he wasn't wearing any clothing or hat or anything around his head, so his head would have hit the concrete first. But he didn't have any skull fractures or anything of that sort. But apparently his shirt and his jeans protected his body from serious external injuries. Dr. Manock, have you read up on the sort of injuries that people get after falling from a height? Oh, yes, he says, I have. And what sort of things have you read? Oh, he says, I read some of my own previous autopsy reports. Oh, after people had fallen from car parks and the like, you see. Very interesting, very illuminating. I don't suppose a book or something would be in there, maybe an article, scientific article, something of that sort. No, nothing like that. That's all thought to be quite satisfactory. When we get to this stage of the time of death, you notice how time of death seems to crop up in these things? Very, very important, very helpful, especially if you have an obliging pathologist. Now, Dr. Manock, the person who did the initial autopsy, she said she thought the time of death was about 12 hours before his body was found. Yes, she did. But I understand that you disagree with that. Oh, yes, I do. So what do you think the time of death was? Well, what she meant to say was not 12 hours before the body was found. She meant to say 12 hours before the body was undressed at the autopsy. I see. And what time was that? Well, that was 8:15 in the morning. I see. And now we know that that's significant because Dr. Manock is busy explaining to the coroner that we actually don't have any photographs of the autopsy. It would be useful to have photographs at the autopsy, we think, but not according to Dr. Manock. Dr. Manock, why don't you have any photographs of the autopsy? Oh, well, that's because we started the autopsy at 8:15 in the morning, and the photographer doesn't arrive in till 8:30. And you think, well, I don't suppose you'd finish the autopsy in 15 minutes, would you? I don't know. Perhaps he was just very quick at it, you know.
Thank you for visiting Julia. The library will be closing in 20 minutes' time.
Oh, well, I better get a jiggle on, hadn't I? Dr. Manick is busy explaining that he died, 12 hours before the body was undressed at the autopsy. But there is a little problem with that. So if he died at 8:15 in the morning, I suppose we could work out that really Dr. Manick is saying that he must have died at 8:15 the previous evening, wouldn't he? Are we agreed? Good. Okay. The only problem with that, you see, is that the police actually found his dead body at 6:30 that evening, which means that he would have died about an hour and a half after the police found his dead body, when it was already stiff with rigor mortis, which takes about 8 to 10 hours to develop, you see. The funny thing is that nobody actually picked up on any of these things and questioned Dr. Manick about it. So clearly we have a pathologist who's in the practice of giving evidence that actually makes no sense at all. I better skip ahead now, as we're going to be turfed out in a minute or two, but I must mention to you about the baby deaths. There were 3 little babies who had died, and they were aged respectively 3 months, 3 months and 9 months. And Dr. Manick did the autopsies for all 3 of them. He concluded they're completely separate cases, no connection to each other, and he concluded that each baby had died of bronchopneumonia. The charges that had been laid against the parents for homicide were dropped, of course, because bronchopneumonia is not a criminal offence, as I'm sure you're well aware. The doctors at the hospital were very upset about this, and they asked for an independent review of the baby deaths. A good friend of ours, who's worked a lot on the Keogh case, did the independent review for the coroner, and he reported back to the coroner that in fact there was no trace of bronchopneumonia in any of the 3 deaths. He explained that identifying bronchopneumonia is a very simple process, and a first-year trainee in anatomical pathology could identify that down the microscope without any difficulty. When it was pointed out that one of the babies had 15 broken ribs, another one had serious skull fractures, and another one had such a serious fracture of the spine that the specialist at the Women and Children's Hospital had only ever seen a case as bad as that once before in his 30-year career, it became perfectly clear that the babies had been beaten to death. The coroner issued a report in which he said that Dr. Manick's work was hopelessly incompetent, that Dr. Manick must have appeared to have seen things that couldn't have been seen, like signs of bronchopneumonia, and that in his answers to questions before the coroner, he'd given answers that were spurious, and that basically means not honest. So he's dishonest, he's incompetent, he sees things that can't be seen, and his autopsies achieved the opposite of their intended purpose. However, the coroner then did a remarkable thing, and he then said, I was aware that Dr. Manick was about to go and give evidence at the Keogh trial next week after I finished my report. And because I didn't want to interfere with Mr. Keogh's trial, I decided to keep my report a secret. So it wasn't disclosed. He went ahead and gave evidence at Mr. Keogh's trial, and was subsequently revealed by the Court of Appeal 14 years later that he'd also given evidence at Mr. Keogh's trial that reported things that couldn't have been seen, like it was suggested that Keogh had drowned his fiancée in the bath. So while she's relaxing in the bath, he comes along, he grabs her leg, lifts her legs in the air, pushes the head down, drowns her in the bath, because he's supposed to be getting married 6 weeks later, and apparently he didn't want to get married to her. So rather than just tell her, look, the marriage is off, he thought, oh, I'll murder her, I'll drown her in the bath. I won't have to get married then, will I? And so Dr. Manick said, I saw bruises on the leg, and it's perfectly clear to me those bruises constituted a hand grip. If it is a hand grip, then she's been murdered, couldn't be an accident. I looked at the brain at autopsy. There wasn't any damage to the outer surface of the brain, so she must have been conscious when she was forced into the water and all this sort of stuff. None of that has any scientific validity at all. And the Court of Appeal, 14 years later, basically said similar things to what the coroner had said in the baby deaths. The difficulty you see is that the coroner had an absolute obligation to disclose his report. The failure to disclose his report meant Mr. Keogh didn't get a fair trial. He disclosed his report 2 days after Mr. Keogh was convicted. From that point on, every person who knew anything about the most basic legal principles would know that Mr. Keogh was entitled to have his conviction set aside. And we made that perfectly clear as soon as we started working on the case. We didn't have to wait another 14 years to create a new statutory right of appeal to get the courts to do what they should have done in the first place. The interesting thing is that when Mr. Keogh's appeal came up, of course he had a right to an appeal, the counsel who defended him, an eminent QC, didn't mention the non-disclosure of the baby deaths report on his appeal. And when we spoke to him afterwards, we asked him about that, and he basically said, look, yeah, that's correct. I didn't mention the non-disclosure of the baby deaths report on the appeal because, first of all, I couldn't see how that would help Mr. Keogh's appeal. And then secondly, I hadn't a chance to read the coroner's report at other than an embryonic level before Mr. Keogh's appeal came on for a hearing. So what that means is an eminent QC, I couldn't read a 72-page report in 3 months, even if it was going to save my client from having to serve out a life sentence for murder. It doesn't make sense, does it? And the difficulty is that when I look at these things and I try and reconcile them with what Mr. MacFarlane was saying about, very often you have prosecutors who make mistakes and maybe get into a kind of mindset where they're not thinking clearly. That can't apply to these types of decisions, in my respectful opinion. One of the particular difficulties that we had with Mr. Keogh was that we kept putting in petitions for him and they kept getting rejected. He was our lead case, and we thought we have to focus on this case to get it through. If we can't get this one through, we can't get any other cases through. So we made it our lead case. As Bibi has explained, we gave up on the petition procedure and then started creating this new right of appeal. When the new right of appeal was created, Mr. Keogh immediately lodged an application for leave to appeal, which was granted, not surprisingly. And when his leave to appeal application was granted, the state then handed over a report that had been obtained about 9 years earlier. Do you remember that 4-year period when we were putting the petition in? During that time, the Attorney General referred the matter to the Solicitor General. The Solicitor General got the head of the Forensic Science Centre to provide him with an independent report, which he did, and in that independent report he said the forensic evidence in this case has been misconstrued. There is no evidence of a homicidal assault. The evidence merely supports the idea that this woman fainted, either from some neurological or cardiac event, and in doing so she struck her head and could have ended up in the bath. There's no evidence of an assault at all. The Solicitor General had an absolute obligation to disclose that report, even if he didn't believe it. But he ought to have believed it because he's the one who commissioned it from the person he thought was the absolute best person to go to get that report. He didn't disclose it, and he then recommended to the Attorney General not to refer the case back to the Court of Appeal because there would be no reasonable grounds on which the appeal could be allowed. We know that that was wrong because the Court of Appeal eventually overturned the conviction on that very basis. So what's going on here? When we went back to have a look at it, we found out a couple of other things which were very disturbing. First of all, when Dr. Manock was appointed in 1968 as the Chief Pathologist for South Australia, he had no qualifications in forensic pathology. Apparently, the deal was we knew that he wasn't qualified, but we thought if we appointed him, he'd then study and get his exams and get qualified. In 1971, he's heading up to the Van Beelen trial, and so therefore we fitted him up with a certificate called the Fellowship of the College of Pathology. We just issued a certificate with his name on it and made him a Fellow of the College of Pathology. The head of the College of Pathology was asked, why did you do that? And he said, you can see it in the ABC Four Corners programme, well, you know, if somebody comes from England and has qualifications, well, we'll give them the Australian one to match it. But a Sally neighbour said, he didn't have any English qualifications. That's right, I remember that now. So why did you give him this fellowship? He said, it was because of the seniority of the position that he held. So because they'd appointed him to a senior position and he didn't have any qualifications, they thought they'd fit him up with some to make him look better. In 1975, the Forensic Science Centre advertised for a senior director of forensic pathology. They thought it's about time maybe we bring somebody in above him, supervise him, make sure he's doing his job properly. And at that point, he sued them for constructive dismissal. He said, look, you've appointed me as the head person. You can't appoint anyone above me. The litigation went on for 6 years. The important thing is this. During the course of the litigation, the head of the Forensic Science Centre went into the Supreme Court of South Australia and said as follows, the reason we have to change this man's position is because he's not qualified to certify cause of death. Now, if you're a forensic pathologist, that could be a bit of a problem, couldn't it? I mean, you might like to ask, well, what's he actually been doing over the previous 5 or 6 years? Certifying cause of death, I think, would be fairly high amongst it, but he's not actually qualified to do that. And is there anything else that you'd like to tell the court while you're at it? Yeah, we'd just like to explain that the other reason we have to change his position is because he has no expert qualifications. What that means is, of course, and you wouldn't be surprised to hear this, that means he cannot give evidence in court as an expert witness, because you do have to be qualified as an expert to give evidence as an expert. That's kind of logical, isn't it? Yeah. So he can't certify cause of death and he can't give evidence in court as an expert witness. Now, the problem that we have, you see, is with this cognitive dissonance thing. You would think that at that point, they would stop him certifying cause of death and giving evidence in court, wouldn't you? But they didn't. They allowed him to continue doing that same job for the next 20 years. He never did any further studies, he never got qualified, and over that period of time, he completed over 10,000 autopsies, and he helped to secure over 400 criminal convictions. And what we're saying is, all of those cases have to be reviewed. If he's done autopsies in one case that he wasn't entitled to do it in, the parents and family of that person are absolutely entitled to be informed of what happened and to have an inquiry as to what went on. For you to have instructed him to do this 10,000 times is way beyond disgraceful, isn't it? And for you to have used him to secure over 400 criminal convictions when he actually wasn't entitled to appear in court at all as an expert witness is also disgraceful. Could I take another 30 seconds just to mention one more case? If you haven't been scared enough already, I do have one extra little story to tell you, and it's about a place called Minterby in the Aboriginal lands in South Australia. In 1978, just as his civil action was coming to an end, he was called to Minterby when an Aboriginal man had been shot dead and was lying on the ground in the main street of Minterby. Dr. Manock came to the scene and he was asked basically what he was going to do with this situation. And he said, well, we'll have to do an autopsy. And the policeman said, are you going to take him back to Adelaide to do the autopsy? And he said, no, I don't think we'll do that. I think we'll do it here. The policeman thought he meant we'll do it in Minterby and hopefully suggested there was a hotel over there with a cool room attached to it. And maybe that would be the best sort of makeshift mortuary we could fix up. And Dr. Manock said, no, you misunderstand me. We're actually just going to do it here. He had a table brought over. He had the man stripped off and placed on top of the table. And then he removed his chest, basically, started removing the internal organs from the body cavity. And after he had removed all of the internal organs, and as the policeman's affidavit says, he did all this in front of the passers-by, the local traders, and people who just happened to be in the vicinity. after the body cavity was emptied of all the internal organs, he took a ladle, took a scoop of the bodily fluids, and it says, with his arm extended towards the crowd, he made an inappropriate remark. What he actually said was, "Does anybody fancy a slurp?" That, as you would hardly be surprised to learn, is a very serious criminal offence. It couldn't possibly be an autopsy. A person at an autopsy can only do what the coroner directs a person to do. You cannot go outside the scope of the authority and direction. The coroner would never give permission for something like that to happen. So he's unqualified to give evidence in court, he's unqualified to do autopsies, and he's committed serious criminal offences in terms of the giving of his evidence and the conduct of situations like this. This has all been on the public record now for the best part of 20 years. And if you look at my website, on the home page of my website, just up near the top of the page, you'll see the Christchurch briefing paper. So everything I've said to you today is referenced in that paper. You can go and have a look at it. And there's also links to 2 comments by the State Attorney General of South Australia. In July last year, the Attorney went on the radio, and we were both involved in an interview, and she said, "Yes, I do recognise that Dr. Manock wasn't properly qualified. In fact, he couldn't have given evidence so that convictions could be properly based on it, and I understand that he was involved in quite a lot of cases." So she said that in the radio interview in July last year. I then wrote to her and said, "Well, now that you've publicly acknowledged this situation, will you conduct an inquiry into what's gone on?" And she started writing back to me to say, "I don't think there's any need for an inquiry. I think these cases can be dealt with on a case-by-case basis as they arise. I don't know of any procedure by which 10,000 autopsies can be dealt with on a case-by-case basis as they arise. I don't even know what arising means. And I don't understand how you could deal with 400 wrongful convictions, because almost all of them will seriously be wrongful convictions. If his evidence is inadmissible, and his evidence deals with the cause of death and time of death, and that is removed from the record of the trial, it's very hard to see how you could maintain a conviction, even if the person is guilty. So we have a situation in South Australia that is completely unprecedented. Never before in the history of the common law in Australia, New Zealand, Britain, Canada, or the USA has the state actually declared somebody to be incompetent and unqualified, and then continued to use their services in that capacity for 20 years after that. So therefore, I'd like to say with you, I'd very much like to join in further analysis of the New Zealand cases, if you would permit us, over the coming months and years or whatever, if we can collaborate in some way. And also I'd appreciate it if you would maybe have a look at what's going on in South Australia. And maybe some of you might like to write to the Attorney General and say, "I think this looks a bit strange. Isn't it about time you actually did something about it?" As Bibi mentioned, the Victorian Attorney General has accepted that there are general problems with the use of forensic evidence in criminal trials, and she's now going to urge all of the Attorney Generals in Australia to conduct a review of forensic evidence in criminal trials, and you can rest assured that we'll be putting in a submission to them to say maybe you'd like to have a look at the ones in South Australia too. Thank you very much for inviting me and for giving me your attention. I appreciate it very much.
So Mark, I wonder if you could close with a karakia. Thank you very much.
I came along this afternoon because I was interested. This is unbelievably sobering for what you've all talked about today. I've spent 23 years working with the tangata whenua, and I know the inequities that are within the system in New Zealand. System where if you've got brown skin, you are 4 to 6 times more likely to be stopped by a police officer. You're 4 to 6 times more likely to be charged. You're 4 times more likely to be multiply charged. You get to the court system, you're 11.5 times more likely to be remanded in custody. In the latest data from Justice, you are now 7.5 times more likely to be incarcerated. That's New Zealand's legal system, and it's been like that for 179 years, and we need to address it. I will finish with whakarakia. A kia tau kia tātou katoa, te atawhai o tō tātou ariki a hiukareite, me te aroha te atua, me te whiwhinga tahitanga ki te wairua tapu, ake, Āmine. And thank you again.